Ready to proceed?
Yes.
Good morning. My name is Kevin McNeill. I'm the appellant. I'm here today representing myself with the court's permission. I'd like to present an argument that's going to take about...
Excuse me, Mr. Do you want to reserve any time for rebuttal?
Yes. I'd like to present oral argument for about 7 minutes and reserve 3 for rebuttal.
Well, you've got 15 total, so if you want to reserve 3, you've got 12. Okay. So reserve 3.
Yes, please.
That'll be fine. You have 12 minutes.
And the 7 minutes didn't include any interaction with the court.
Oh, yeah. You don't have to use the full 12 minutes, but you have it if you want to.
Quicker is better. Your Honors, on March 6, 2019, 1,260 days ago, I, a 67-year-old retired professional investigator and citizen activist, was trespassed from government property open to the public. The ban is for life. The defendant claimed in his trespass order that I was a safety risk to a hospital employee. Before I proceed with the possible errors of the lower court, I would like to briefly touch upon the civil rights violations and the cause of action. Denial to travel freely on government property open to the public. Equal access to Medicare-funded medical care, a property right as determined by the Supreme Court of the United States. Interference with my First Amendment right to gather information of public importance in support of free speech. Banning me from the hospital board of directors meeting, a public meeting. Banning me from viewing public records. Denial of due process by both the hospital and the county, Blount County, when they refused to redress my petition of grievance asking that the circumstances surrounding the trespass and my concerns of malfeasance at the hospital be reviewed by an impartial panel. And finally, the lower court denied me the right to face and question my accusers at a jury trial that I had requested. My request to this court is to reverse the district court's dismissal order and let a jury trial be held. Allow me the due process to face and question people who said that I was a threat to the safety of an employee and disruptive to hospital operations. I will briefly describe the district court actions that deserve your consideration. First, the case dismissal effectively upheld the hospital adverse action of a lifetime ban of liberty to travel freely on government property open to the public without hearing any testimony from witnesses other than myself. The district court granted the plaintiff's amended complaint, making the original complaint that I had filed without legal effect. But minutes later, the lower court heard and ruled on the summary dismissal motion. That motion was based on the now mute original plaintiff's complaint. The amended complaint was allowed by the lower court, but seconds later discarded from consideration. The amended complaint approved by the district court was filed, but a response was never made. Please note that the motion to dismiss was filed on March 2021 by the defendants, while the amended complaint was not filed until August of 2021. Next point. Upon granting the defendant's motion of summary judgment, the district court did not record its own independent analysis and judgment, as required by the Tennessee Supreme Court rulings. The district court simply read from the defendant's motion of dismissal The transcript of the court reading directly from the plaintiff's motion of dismissal was appended to the court order. The lower court judge did not opine his own legal interpretation on why he dismissed this case. The lower court hearing of August 13th, 2021, the district court refused to hear motions the plaintiff, myself, asked of the court to schedule. During the hearing, the district court stated that the motions were not on the docket and would not be heard. As background information, Your Honors, the plaintiff, myself, had filed the motions with the court that listed 9 specific motions to add to the hearing. The United States Post Office delivered the certified letter to the judge's office on July 26th, well in advance of the August 13th hearing date. Just a little bit of background very quickly. Prior to the trespass, I had been an outpatient of the hospital. I was a resident in a leased apartment within the hospital-owned senior living facility. I had publicly declared my desire to become a board member of the hospital, a community-owned hospital. This lower court case, district judge acknowledged my desire to become a board member well before the trespass in his email to me of February 2019. I attended public hospital board meetings that were held within the hospital I can no longer access. I made 12 public records requests and viewed public records within the hospital. I had scheduled one meeting with an individual and an unscheduled meeting with an individual. Both of those meetings were held in a private, closed room. I was a volunteer at the hospital. I drove seniors to medical appointments and other appointments as a member of a second organization called Smiles. The hospital represents 65% of my senior rides. I visited friends at the hospital. I want to mention 2 very specific events. On February 2nd, before the trespass, 1 month before the trespass, I met with Don Heineman, hospital CEO, to discuss my concerns, specifically years of operating losses, 9 out of 11 years of significant operational losses. The second major issue I discussed with Mr. Heineman was $20 million worth of medical business acquisitions. They bought businesses from friends and colleagues. My research showed me that the price paid was significantly higher than shareholder equity as reflected on tax returns. On March 1st, 2019, this is the second event, I went to Knoxville and legally entered a non-hospital business. That business was owned by a doctor who worked at the hospital. I spoke to a hospital employee who was managing that private business. I asked her about her name appearing on the purchase agreement and a $280,000 salary compensation payment. She denied any knowledge of the contract. On March 6, 2019, the hospital director of security trespassed me from the hospital properties, stating I was a safety risk to the employee I visited in Knoxville. In her affidavit of June 2020, the hospital employee stated, and I quote from that affidavit, "I do not believe I am in any danger of being harmed by Mr. McNeill." I later learned, before being trespassed, that the director of security has solicited statements from 4 members of the administrative staff. Those 4 statements are all dated within 6 days. In closing, Your Honors, I can no longer enter the public spaces of the hospital except for personal medical treatment. The loss of my civil liberties is so individualized, so severe, and long-lasting that due process must be protected. I'm looking for an impartial jury. An impartial jury should decide the merits of this case. In closing, I plead with this court to overturn the lower court ruling and allow me to use the trial process to state my facts and to question witnesses. I thank you for your time and attention.
You have your time for rebuttal still.
Thank you, Your Honor.
Thank you. Here from counsel for the appellee.
Please the court, Luana Atkins, practicing with Goddard and Gamble in Blount County, representing the appellees, Blount Memorial Hospital Incorporated, and Erwin Donald Heineman, its former CEO. The appellee is a governmental entity as defined by Tennessee Code Annotated 292102. And Mr. Heineman was, at the time relevant, its CEO. In his discretion, after multiple employees' complaints, they determined that Mr. McNeill should be no trespassed. This case actually arises because the appellant ignored Blount Memorial Hospital Incorporated's policies and procedures regarding requests for public records after being directed several times. So the administration determined that he should be no trespass, with the caveat that he could come for medical care. But let's look at the appellate's brief. Just as he ignored the rules of the appellee's public records request, and he ignored the requirements of Rule 56 below, and the local Rule 5 below, he also has ignored this court's rules and the Tennessee appellate procedure rules. And his brief is very lacking in the requirements of both rules, in that it doesn't contain appropriate references to the record in his statement of facts, appropriate references in the record in his argument, or a concise statement of the applicable standard of review in his discussion of the issues or under a separate heading. This court has found that if an appellant's brief does not comply with Rule 27 of the Rules of Appellate Procedure or with Rule 6 of this court's rules, that the appellant has waived the issues he raises on appeal, and the appeal is generally dismissed. However, it is understood that pursuant to Tennessee Rules of Appellate Procedure 2, this court does have, for good cause, may suspend the requirements of the rules regarding the form and the contents of an appellate's brief. So we will address the issues raised by the appellant in his brief and show that the trial court did not err in moving forward with the hearing on the motion for summary judgment, because the amended complaint mirrored the original complaint. The trial court did not err in granting summary judgment, and the trial court did not err in declining to follow the appellant's proposed agenda for the hearing and denying and dismissing any remaining motions as moot. And the trial court did not err in directing the appellee's counsel to draft the order memorializing the trial court's bench ruling with the transcript of that ruling attached. This is an unusual procedure for this court. It was an unusual procedure for me. Generally, this court deals with the denial of an amendment and the grant of a motion for summary judgment, or the grant of summary judgment without addressing the motion to amend. Although this is unique, the trial court's moving forward was appropriate in this matter
Why?
because the amended complaint and the original complaint had the exact same facts, the exact same issues, and the exact same parties. And all of that was addressed in the appellee's motion for summary judgment, because in the original complaint, the appellant based his claims on due process, that he was denied due process, which brings in the First and the 14th Amendment, which wasn't stated in the original complaint, but the motion for summary judgment by the appellees did address that, because that comes into play on a claim for a violation of due process. In the, we'll compare the complaints. Count 1 in the amended complaint says that the appellant was deprived of liberty to move freely on government-owned, open to the public property. In the original complaint, he stated he was entitled to due process before his right to enter public property can be deprived. Those are the same issues. And the only difference is that he stated in the amended complaint that that was under the First Amendment of the Constitution. In the original complaint, he claimed that it was under the Tennessee Constitution. However, we know that Tennessee does not recognize a private action under its Constitution. However, if he claimed due process, it was addressed in the motion for summary judgment and argued before the court. In count 2, the appellant claimed that his right to examine
Counsel, I'm sorry, so you're saying the amended complaint, he raised the Tennessee Constitution and he hadn't raised it in the original complaint?
In the original complaint, he tried to claim his due process rights under the Tennessee Constitution.
In the original complaint?
In the original complaint.
Okay.
He changed that to the United States Constitution. However, there still was no violation, and the U.S. Constitution and the Tennessee Constitution were addressed in the motion for summary judgment. Actually, in the appellant's response to the motion for summary judgment, because it was cited in the motion for summary judgment, he said under his authorities was the United States Constitution and the 14th Amendment. So he even addressed it in his response to our motion for summary judgment. In the claim, in the amended complaint, he claims that he has the right to examine proceedings of a governmental entity under the First and 14th Amendments, but he speaks of public meetings and public records requests, which are under Tennessee statutes, not under the Constitution. And in the original complaint, he stated he has a right to investigate a governmental entity, and he used those same Tennessee statutes. In the amended complaint, he said he had a right to access the hospital's public meetings and a right to view hospital records. In the original complaint, he said he had a right to investigate a governmental entity by denying him access to public records and public meetings. He made the exact same claims, the facts were all the same, and the parties were all the same. The only difference was the headings. Now, when a court does grant a motion to amend, that motion, that amendment does supersede the original complaint. We have no argument with that. What the case law says, though, is that, and this case was actually cited by the appellant in his brief, the court held that when a plaintiff files an amended complaint, the new complaint supersedes all previous complaints and controls the case from that point forward, which is exactly what happened in the court below. The as evidenced in the transcript, the trial court, the appellees, and the appellant proceeded with argument for summary judgment on the amended complaint. The court announced after a short recess that we will hear the motion for summary judgment on the complaint as amended. The appellee's counsel began by addressing that the motion for summary judgment would be against the amended complaint and that some of the argument would be the same as the preceding argument on the motion to amend. The appellee's counsel referenced the amended complaint in argument of its presented issues. The argument addresses the issues as presented in the amended complaint, i.e. the First and the 14th Amendments. The appellant addresses the amended complaint in his argument. Accordingly, the amended complaint controlled forward. Regardless, the appellant did not object at the court below to hearing the appellee's motion for summary judgment at the time and fully participated in the argument. So the trial court did not err in moving forward on the motion for summary judgment. The trial court didn't err in granting the summary judgment. A civil case that can be resolved solely on the issues of law is appropriate for summary judgment. The appellant agreed with the appellee's statement of undisputed facts in his response, and the appellant's noncompliance with Rule 56 foreclosed any factual dispute that needed to be resolved. Accordingly, the trial court correctly decided the case on the legal issues alone. The motion for summary judgment was granted upon the court's finding that not only have essential elements of the plaintiff's case been negated, the court finds that the plaintiff cannot prove his claim. And based on that, the court found that there was no genuine issue of material fact and that the defendants were entitled to summary judgment as a matter of law. As to Mr. McNeill's claim of a jury trial, this is a governmental entity. The Governmental Tort Liability Act puts that jurisdiction exclusively in the circuit court, so he is not entitled to a jury trial because there is no non-governmental party in this matter. The trial court did not err in directing the appellee's counsel to draft the order memorializing its own bench ruling with the transcript attached. The trial court actually explained to the parties that it had reviewed the motion, the response, and the statements of fact at the beginning of the hearing when it was stated that it would be a lot of deja vu in the subsequent argument. In its bench ruling, as it stated, that the trial court found that the appellees had negated an essential element of the appellant's case. So with no factual decisions needing to be made and based strictly on the law that we had negated his case and that he could not prove his case, his claims, then the court was properly granted motion for summary judgment and properly directed the counsel to draft the order. This court has held in Smith, the case cited by the appellant in his brief, I misspoke. The Tennessee Supreme Court has stated that the first principle reflected in Tennessee Rule Civil Procedure 56-4 is that the trial court shall state the legal grounds upon which the court denies or grants the motion for summary judgment, which shall be included in the order reflecting the court's ruling. The second principle is that after the trial court has decided a summary judgment motion, it is permissible for the trial court to authorize counsel to prepare and to submit a proposed order for the court's consideration. And the order that was prepared by counsel was sent to the appellant for approval and for permission to sign his name, which was granted. So the trial court did not err in that matter. The trial court didn't err in declining to follow the appellant's proposed agenda because the court has the discretion to take care of its own proceedings. And Mr. McNeill did not follow Rule 5, and it was explained to him, and he had set motions for hearing before. He set his motion to amend for hearing, so he understood the rule. Those motions were not set for hearing. The court did state that the hearing dates on motions, the Rule 5 states that hearing dates on motions except for hearing dates set by the clerk shall be confirmed with the judge's secretary and then confirmed in writing with the judge's secretary, which he did not do. The trial court didn't err in declining to follow that. Also, the appellees, Mr. Heineman, is by the Tennessee Governmental Tort Liability Act, is allowed fees because he was sued in his individual capacity, and if we are successful here, he will be the prevailing party.
Thank you. Mr. McNeill, you have your time for rebuttal, your 3 minutes for rebuttal.
Thank you, Judge. First, I'd like to address the changes between the original complaint and the amended complaint. A year after I wrote the original complaint, I read it, and I came quickly to the conclusion that it was not up to the standards that the court is accustomed to. As a non-legal person, I did my best to prepare that. After a year of searching and researching, the major reason I changed the complaint was to, in the supremacy definition, to raise it up to the federal level underneath 42 U.S.C. 1983. So the secondary issues around public records not being supplied to me, those counts I removed because I felt like they were, though I believed that there was infraction, they were secondary and I didn't want to dilute the case. So I focused solely on the civil rights issue and presented a template that the court was accustomed to. I also remind you that the filing of the amended complaint has never had a response. The reason I'm standing before you and the reason I've invested so much personal time in this is that I believe that citizens have a right to transparency of government organizations. I'll argue at trial that those rights were interfered with and that this statement of being a safety risk was an excuse to prevent me from accessing records that I had already demonstrated that I was capable of doing. So to this court, I would suggest that this issue around a citizen's right to public record is so significant that you should allow it to go before a jury of my peers and be reviewed. And then finally, Attorney Atkins brings up a number of what she suggests were improprieties of the way I proceeded underneath the legal system. Quite frankly, I don't know if she's right or wrong. That's really up for you to decide. But what I would like to see is that if my plea around access to public records has any merit with you, then use the full discretion of the court rule that allows you some latitude with a non-trained person and allow this to be heard by a jury. Again, I thank you.
Of course, thanks to both sides. We appreciate your oral arguments this morning.